Right. Still with me is Los Angeles County Deputy Public Defender Philip Dubé. And Philip, there's a lot going on here, and I want to get your impressions because there was a shooting prior to the tape that everyone is familiar with. I'm sure you've seen it. I'm sure most of our viewers have seen it. And there was an incident with Rosenbaum. And of course, you heard the defense attorney there saying that there were some threats made. He also goes on to say that he was actually after Kyle's gun, and that's when the shooting took place. There was also a gunshot in the background that might have added to the environment. So it's really about the totality of the night, not just about that one video we've all pretty much seen.
Yes, I agree. I think the issue for this kid is going to be why he went there with the gun, right? I mean, obviously, the prosecution's theory is going to be he went there to massacre people during that unrest. If you recall, there was a shooting of an unarmed, I think he was unarmed, it was Jacob Blake, a black man that caused the entire Kenosha unrest. And in going to the scene, I think he thought he was going there to help protect property. So he didn't really go there with the intent to harm or to injure or to kill. However, during this unrest, he perceived people coming after him and certainly reaching for the gun. The gun put him at risk of great bodily injury or death. And this jury is going to have to decide if it was reasonable under the circumstances for him to have the upper hand first. He was quicker on the draw to protect himself. Because let's face it, what would have happened if this guy would have gotten the gun away from him? If he would have gotten the gun away from him, maybe he would have shot at Kyle. And you have to put yourself in the mind of this kid. He probably really thought at that time his life was in danger. Now, I could see the prosecution also asking for a lesser or perhaps the defense of manslaughter, where I believe in Wisconsin, if somebody acts with an honest but unreasonable belief in the need to use self-defense, the jury can return a verdict for voluntary manslaughter, which is a defense victory because it does not carry life in prison.
Yeah, no question about it. And you know, that's scene number one. So they'll be judging that one. They'll have to ferret out all the different information they'll get about that confrontation with Rosenbaum. Now let's move on to the one that we're more familiar with, the one that happens in the middle of the street. And I want to go through that quickly with you. Here's the context. My understanding is, and from watching the video, is that folks are screaming that, you know, stop that guy. He's running down the street. They're saying, stop that guy. He shot somebody. That's when Anthony Huber comes into the scene, seems to hit him, or he has a skateboard, and he's certainly using it as a weapon, swinging it at him. Let's talk about that shooting. Do you think there, under those circumstances, with everything else I just mentioned going on around them, do you think there's a clear case for self-defense there? Now, again, this is not a deadly weapon. It's a skateboard.
Oh, let me tell you something, Michael. Out here in Los Angeles, we get a lot of cases brought into the courthouse where I'm at, the airport courthouse, where you have people whacking each other with skateboards on the Venice boardwalk. Let me just tell you, not only does it hurt, but it can kill you. It can break your orbital bones. It can break your jaw. I cannot tell you how many cases I've had that resulted in victims being hospitalized due to broken bones and facial injuries from people cold cocking other people on the boardwalk with a skateboard. It's very common and it is very dangerous. If somebody is coming at you with a hard piece of wood, aiming it at your head, that is a deadly weapon, especially if you have nothing to defend yourself with. What are you supposed to do? Run or duck? They'll keep swinging it at you. The goal at that point is to try to disable or to harm you. Plus, you've got a mob scene going on. You have a huge mob with somebody coming at you with a skateboard. I got to tell you, I think worst case scenario for this kid is an imperfect self-defense where he had an honest but unreasonable belief in the need to use self-defense.
Interesting. Let's move on to the next confrontation. Gage Grosskreutz. This guy has a gun. A little bit of different. Yeah, actually, based on what you just said, it's almost the same set of circumstances. Because I could almost call you as a as an expert witness for the defense, talking about those skateboards. But again, a deadly weapon, clearly in his hand, a gun in the video. How does that affect things?
Well, that changes it from an imperfect to what we call a perfect self-defense. That's exactly what it is. It's a justifiable homicide. You know, the most sacrosanct thing that we have in this world is our life. And the law, particularly in Wisconsin, California, I'm sure in Georgia, where you're at, allows you to use deadly force to save your own life when there's an imminent threat of losing it. So, yeah, someone's coming at you with a gun. Are you supposed to stand there and guess and wonder and surmise if it's loaded or a toy or a replica? No. You shoot first and ask questions later. Otherwise, you might be the first man down.
What role does it play that perhaps he had the gun illegally? He should not have had that gun in the first place. He's too young. There's some issue under the statute, but let's say it turns out he's not supposed to have the gun. Does that play any role in the determination?
Then you charge him with being in unlawful possession of a firearm. Again, from a defense standpoint, going down on a weapons charge is far better than facing life in prison for a homicide. Okay, so be it. Bring that charge. I'm sure he'll take the deal.
All right. Incredible insights. I truly appreciate that, Philip. And we'll be looking out for all that. I've said it before. This one's certainly not a slam dunk case. All right, stand by, Philip. We're going to take a quick break. And don't forget, I want you guys to watch Court TV's in-depth special report, Chaos in Kenosha, the Kyle Rittenhouse case, this Sunday at 9 p.m. Eastern, right here on Court TV. And as you saw, it includes yours truly. And when we return, we're going to have our Daily Talkback segment where we ask you, since both the McMichaels and Kyle Rittenhouse are claiming a case of self-defense, we asked you, which one has a better claim to self-defense? We'll have your comments right after the break, so keep it right here on Court TV. Hello and welcome back to Court TV Live. I'm Michael Ayala. It is time now for today's Talkback segment. Each day we post a question on Court TV's social media pages. We gather your comments and questions and then respond right here on the show. Today we asked you, since both the McMichaels and Kyle Rittenhouse are arguing self-defense in their cases, which case do you believe has a better argument for self-defense? Still with me is Los Angeles County Deputy Public Defender Philip Dubé. And Philip, our first comment comes from Napoleon Maddox. He says, Rittenhouse, but I rate his chances of less than 1 in 10. He wasn't defending his home. He acquired, possibly illegally, a firearm. He crossed state lines looking for trouble. His actions were highly provocative and designed to elicit a response. Until we see the full videos, it's tough to tell. But it looks like those injured or killed acted to prevent Rittenhouse from shooting others. They interceded against an armed perpetrator to prevent a crime and ended up paying the ultimate price. Wow. Wow. I get a sense, and I'll be honest with you, I think that sounds like at least part of what the prosecution is going to argue, but I know you don't agree with that just by our previous comment.
Well, if the question is who I think has a stronger self-defense case, I do believe it is Kyle Rittenhouse. I truly do. Yes, he did go there with a gun, but that's not unprecedented, Michael. Do you remember, I think it was in the 80s or the 90s, when Bernie Goetz went on trial in Manhattan for carrying a gun during the time when, people were getting mugged constantly and robbed on the subway in New York City, and beaten and knifed and shot. And no, he was quicker on the draw. He was approached, he pulled the gun out, and he shot. So in the end, he was acquitted of murder, but the jury got him on the weapons charge. But in the end, in his mind, he felt the need for self-defense was appropriate. It was of sound judgment at the time. With Ahmaud Arbery, you just have a young, unarmed kid leaving the scene, being chased and hunted down by 3 people. I think they're going to be hard-pressed to sell self-defense to a jury. I think those 3 men are going to crash like the stock market.
All right, let's go to our next comment. That comes from Arthur Moore. He says all 3 should go to jail. They chose to put themselves in this position. I imagine he means actually all 4, quite frankly, is I think what he means. And let's bandy that about. I want to go back basically to the previous comment. And again, it talks about the totality of the circumstances, the fact the gun was illegal, the fact that others were trying to stop him. They were being told, hey, he shot somebody. They may have been trying to stop him. But you don't think that when taken into account all that way, it was still reasonable for Kyle to believe that he was in danger, reasonable for him to use his gun. And that's what's going to be most important in this case?
Yeah, I think you got to put yourself in his mind at the time. And when you see a 17-year-old being chased and hunted down by a mob, and there is somebody with a gun or somebody with a skateboard coming to whack you, in the mind of a 17-year-old, it probably really was reasonable for him to turn around in the honest belief that he was going to suffer great bodily injury or death. Whereas with Ahmaud Arbery, I don't think those three men really thought for one moment that their lives were in danger. It was 3-on-1, and they brought a gun to a slugfest.
Yeah, fair enough. Our next comment comes from Roger, and he says Kyle, at most, will get convicted of misdemeanor weapons charges, no jail. He seems like an odd do-gooder that also happened to be heavily armed. If you want to deal in hypotheticals saying that he shouldn't have been there, then it could also be hypothetically said that nobody should have been there. Interesting point of view. I think that mirrors some of the things that you were saying. In fact, that, he was indeed a good do-gooder. And the only thing that really he might be found guilty of is weapons charges. But I ask you, there are 3 dead bodies. Do you think a jury's really going to look at this case and say, the only thing we're going to get you on is misdemeanor weapons charges?
Well, it's very possible that there'll be a split verdict. They might find him not guilty of one homicide, and they might, as to the skateboard guy, find him guilty. Maybe they felt rather than shoot him, he could have, pistol whipped him, or taken the butt of that rifle and just whacked him rather than discharge it. It just depends. Not only that, it also depends on how much time Kyle had to react to that thing coming at him. So I think it's very fact specific, and I'm not sure that the video really captures everything, at least that was going through his mind.
Yeah, I would imagine you think he'll have to take the stand and tell his story. I don't think there's a downside to that, or is there?
Oh, no downside whatsoever. I think this is the perfect case where, as long as a lawyer sits him down and prepares him for cross-examination and understands what it means to be honest and truthful, seriously, I think a jury could embrace him.
I think there is a small downside, though, Philip. There's a lot of information about some things that he said about some shoplifters, that he wished he had his gun, some other things that I think might, if he testifies, it would open the door to that stuff. So they may be weary about that. But I think ultimately it might be a win for him there. Let's go to our next comment. It's from Laura Lane. She says, Greg and Travis have no self-defense case. Kyle's situation is 100% different. The question I have about Kyle's situation is when you don't get to claim self-defense when you create the situation. I'm wondering if you think there's an element of him creating this situation by bringing this illegal gun into this situation and now trying to then step back and say, oh, I had to defend myself. What do you think about that?
Well, you have to understand that the genesis of this entire unrest was the gathering of a mob. Right? This was not just a peaceful rally. This wasn't just a peaceful march. This was a group of people up to no good. There was violence. There was looting. The behavior of everybody involved in that unrest was very unpredictable. And for someone to, by happenstance, have a gun and it became necessary to use it, I think a lot of jurors might say, well, thank God he had it. Because what would have happened to Kyle if he didn't have a weapon? Who knows? Maybe somebody else will be on trial for whacking him in the head with a skateboard.
Yeah, I think you're absolutely right about that. So again, I think picking that jury is going to be very important. That begins next week, and they'll have actually 2 days to pick a jury, and we'll cover that here as best we can on Court TV. All right, Philip Dubé, I want to thank you so much for joining me on this Friday. Always a pleasure. I want you to go out and have a great weekend. All right, Daniel. We'll see you again soon.
Likewise.
All
Take
right.
care.
You take it easy.